good afternoon to all of you. When I got the request from Mr. Anantanath to come to this program, I asked him, what do you want me to speak on? And I am a judge of the Supreme Court. I can speak on Article 19(1), your freedom of speech and expression, which also incorporates the freedom of press and the media. He said, no, we are more concerned with Article 19(2), which imposes restrictions on the freedom of press. So that is where I start from. And then I see your concerns, media concerns. I've been reading about those in the newspapers. I will suggest some changes which you can take up with the government, and some which you cannot take up with the government, you have to take to the courts. Right. This is the only remedy that you have. And I must tell you, I was here in the previous session. I also wanted to be a journalist. First a doctor, then I gave up pre-medical, then I studied a lot of political thought, political science. Then I thought I become a journalist. But then I started thinking, where will I get the money from? Survival would be very difficult. So I gave that idea. I am not that fortunate as Ananga Patnaik, who has a sambad already to start with. So I gave up that. Let me look at the profession where I can also earn good money and remain independent. That is how I joined the legal profession, where I earned well, but my earning was very limited to 20 years, and the judiciary picked me up for judgeship, and I became a judge for more than 20 years, 20 and a half years. So therefore, I'll start from Article 19(1)(a) and then Article 19(2). As you all know, under Article 19(1)(a), all citizens have the right to freedom of speech and expression. There is no mention of media there. There is no mention of press there. But the Supreme Court has said freedom of speech and expression means also freedom of the press or freedom of the media. That is incorporated in it. And then the courts have said freedom of speech and expression for media cannot be anything more than that of the citizen. So whatever limitations are there for a citizen, those limitations also apply for freedom of press or media. They cannot ask for more. Because Mr. Anantanath had sent me some letters addressed to the Prime Minister and then to the leader of the opposition. They went through it. And he's asking for some exceptions. I thought over them. I said, how can there be exceptions? If the freedom of speech and expression for the citizen and the freedom of speech and expression for the media is same, they cannot carve out an exception for media separately. Whatever limitations are there for the citizen, whatever law they have to face, whatever consequences they have to face, media also has to face them. So this is one thing that must be clear. We can't carve out exceptions for the media in the name of independent journalism or for democracy, so on and so forth. Now, Article 19(2) says, nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law in and so far as such law imposes reasonable restrictions, very important, reasonable restrictions. So it's not any restriction, reasonable restrictions on the right conferred by the said clause in the interest of sovereignty and integrity of India, This is number one. Number two, security of the state. Number three, friendly relations with foreign states. Number four, public order. Public order was not there originally. It was incorporated subsequently by Pandit Nehru's government by the First Amendment, because they found the Supreme Court struck some acts down. They say, yes, it may be affecting public order, but it is not protected under 1992. So therefore, public order was subsequently incorporated, which has created a lot of problems. Because all the offences basically try to maintain public order. Decency or morality, or relation to contempt of court, defamation, or incitement to offence. Now, let me come how the law was therefore brought in. There was the Indian Penal Code earlier, and now the Bharatiya Nyaya Sanhita 2003 has come in. And I would quickly tell you, I need not go through the provisions. Section 152 of this new law is same as sedition, 124A. I have a chart, and I can also compare them for your information. So 124A Indian Penal Code is kept intact in section 152. There may be some changes in words here and there. Then 196 of the new law is equivalent to 150A of the Indian Penal Code, and that relates to promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., on doing other acts prejudicial to harmony. Obviously, this is to ensure that the public order is maintained. You are seeing in the newspapers somebody criticizing a particular religion, and then that group of religion who has been affected, they start pelting stones on the other groups. So many law and order situations come. They are all justified provisions. Maybe the language may be creating problem. Then 197, imputation, assertions and prejudicial to national integration. This also is very important. You can't just say this kind of a law should not be there. Then 299, deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs. Very much necessary today. Right. Then next, 302. 302, it says uttering words, etc., with deliberate intent to wound religious feelings of any person. And then 356 is defamation. So there is a debate so far as defamation is concerned, because it affects really, it does not affect law and order. It affects an individual. Why not just have a tortious liability, civil liability, damages? A debate. In many other countries they have given up. This can be thought of. The legislature can think of this, get rid of defamation as a criminal offence and put it as anyway, it was challenged before the Supreme Court. And the Supreme Court said, no, this reputation of a person is very important. This should remain as a criminal offence. And that is how, since the Supreme Court has already justified it, you can't say that this defamation provision can go. There was a chance for the Supreme Court to say otherwise, but they didn't do it. Right. Now, the problem here is, in all these provisions, in many cases where the offences are not really made out. I was hearing last session, the state government or the central government, they don't like all this criticism. So they would like to mobilize their police machinery and book all these journalists who are criticizing them, some offence or the other. And police starts acting. It's not happening only in central government, it's happening all over the state, all over the country. You see Tamil Nadu, they are doing the same thing. If you see Karnataka doing see. I heard Ruben saying about Odisha, they were also doing the same thing. In Bengal, they are doing the same thing. They will not leave. Because political power is such, the state machinery is mobilized against any criticism. And they have to just find out which particular section you booked in. They don't dictate the section. They only ask the police people, this, take action against him. I don't know what law you find a law and book him. This is what they do. And they find a law and book it. Now, when the matter goes to the magistrate, in 24 hours they have to be produced before a magistrate, whoever is booked. That is the constitutional provision in Article 22.2. Right. It says, any accused has to be produced before the nearest magistrate within 24 hours. Any detention beyond 24 hours will be only with the authority of the magistrate. So it is for the magistrate to apply their mind and find out in which case the arrest is proper, in which case arrest is not proper. Unfortunately, and I am saying that even though I have been a judiciary for so long, unfortunately, the magistrates do a very mechanical job and they don't apply their mind. In my opinion, the magistrates should be very committed to these constitutional provisions, be committed to liberty, and ensure that no innocent person is detained beyond 24 hours. This is what has gone wrong with our country. I have been the Chief Justice in Madhya Pradesh, and I put this question to my student, why are you not doing bail? Why are you not applying your mind? But they don't do it mechanically. They are not that committed to liberty. This is the sorry state of affairs. So what is the remedy then? What is the remedy? The remedy, I think, is, in the present state of the guild and the press, media all over the country must move the government to bring about some amendments in the law. Not as an exception, because I said, you cannot be accepted from the other citizens, but to provide checks against wrong arrests or abuse of these provisions, penal provisions. How can that be done? As you know, all of you know, under the CRPC, old CRPC, there is a provision for sanction of prosecution of government servants. Before a court can take cognizance of an offence, sanction of the government is necessary. Even under the Prevention of Corruption Act, sanction of the government is required, competent authority. Before the court can take cognizance. So that acts as a check that a wrong person is not being unnecessarily, the facts are examined, wrong persons are not being unnecessarily booked by the police. Right. Even on the Mining Act, Development Act, there is a provision that nobody else except the mining department of the state government will sanction an offence related to mines. So these are normal provisions. I would suggest you should move the government to provide some check, not of the government, not sanction of the government. One authority could be the Press Council of India. And one of the functions of the Press Council of India, you know, I understand that Press Council of India is not very active, right? But it is headed by a Supreme Court. It has to have a, some provision. There is no provision there. Or some body, some independent body which will examine, let the police complaint come before them, or let a private person make a complaint to them, and let that body examine it, and give sanction only where it is satisfied there is no misuse of the offensive provisions. This is very important. This check can work on. Absolutely. But you can't be accepted from the normal law that is applicable to all citizens. This is a suggestion that I gave. You can work on it. Now, the second area as you know, contempt of court is part of Article 19(2) of the Constitution. Don't have to be bothered about contempt of court, because contempt of court means ultimately the court has to decide. And civil contempt, you will not be called on to answer. That means disobedience to the orders of the court, or writs of the court, or judge in the court. That normally the media is not concerned with. It's only one party. Unless you are a party in that case and you are disobeyed. Like you saw in the Ramdev case, how he's being summoned all the time, right? Because they are not disobeying. That's why. Now, so far as criminal contempt is concerned, there is a danger there. Criminal contempt has been defined to mean the publication of any matter, so far as you are concerned, which scandalizes or tends to scandalize or lower the or tend to author of the any court. Like an evidence, you may publish it something. I'll give you an example. Prejudices or interferes or tends to obstruct any judicial proceedings. Some case is going on, though the courts don't exercise it. I remember in that Nupur Talwar, how much of interference the media did. Media almost convicted. And I was sitting in the court when I saw the CBI gave a closure report, but yet the court opened it up. I said, no closure report. They have to be summoned. So when the matter came to the Supreme Court, I said, why is someone when the CBI is given a closure report? But my colleague, my brother judge said, no, sir, let it remain. Because the media was affecting and CBI was also there supporting the media. Take out. And I was sure that ultimately this will end up in acquittal. And it happened. Allahabad High Court acquitted them. But the family suffered a lot. So, this is the next example. Then interferes or tends to interfere with obstructs or tends to obstruct the administration of justice in any other manner. This is a very broad thing. So, when administration of justice is affected or when this court is scandalized, authority is gone, is eroded, then there is a problem. Who will respect the court then? That is why these contempt provisions are there. And contempt provisions also have, in the Contempt of Court Act, there are provisions, innocent publication and distribution of matter, not contempt, they have said so, in Section 3. Section 4, fair and accurate report of judicial proceedings, not contempt. And Section 5, fair criticism of judicial act, of judgment, after it is published, not contempt. And finally, they have said, even if you do contempt, apology, if somebody comes and gives an apology, mistake ho gaya, the court normally will say, all right, take an apology and go. So contempt of court is no problem. Sometimes it is a problem. I'll give you, I had an opportunity to handle once. When I was a lawyer in Odisha before my elevation, and Mr. Biju Patnaik was the Chief Minister, suddenly I received a letter from Mr. Biju Patnaik in a personal envelope, and I opened up. He's written it in his own hand. On the top, Sri Ananga Patnaik is requested to defend me in the High Court in this case. And I opened up the papers and found it was a summon issued by the High Court to him for contempt. And what was against him and against your paper, Samaj. You know what he had done? In one meeting, in one meeting, he went to the stage in a conference and said, the High Court judges are like white elephants of Siam, right? Very expensive to maintain. 2.5 lakhs we spent on each High Court judge. Every month, Mr. Tathagata Satpathy was among that, right? And is it justified? Is it giving relief to our poor people? So somebody a lawyer filed a petition in the High Court. Huh? Yes. He's a lawyer. He filed a petition. And Samaj as the second party, first party, Biju Patnaik. And I had to defend him. So I telephoned to him. I have to draft an affidavit to show cause reply. Have you given this statement? Yes, yes. I have given that statement. No mistake about it. Don't disown it. You defend me otherwise. So I defended. And it was a division bench of Justice P.C. Mishra and Justice G.B. Patnaik. And my argument was, look here, every citizen has a right to criticize an expensive system of justice, including the High Court. He is not criticizing any particular judge. Every citizen has a right. Right. And then I cited a judgment of the Supreme Court Justice Sabyasachi Mukherjee, where the Law Minister of India had given a statement somewhere in the south. Shiv Shankar had given a statement that Supreme Court is a class institution. It has number of bourgeois and this class and that class. As a result, justice is not coming. Right. So that petition was dismissed by Justice Sabyasachi Mukherjee. He cited a very good judgment of Lord Dennings, which said that, see, on the one hand there is contempt, but on the other hand, something greater is at stake, democracy. Freedom of speech and expression, that's necessary. You must balance it. You can't just give contempt big priority. So, what I am saying is considering this approach of the courts, not to haul up people for contempt, be approached. There's another example I'll give you. Justice Krishna Iyer was the bench, Justice Beg was the Chief Justice of India. A letter was written by Justice Beg, the registrar to the High Courts during emergency, that why High Court is not doing this, High Court is not doing that, High Court are not doing this. Right. Then somebody took it out of the newspapers that during emergency, High Court has been functioning much better than the Supreme Court. So this came out in the papers. Justice Beg issued contempt notice. Well, High Court is doing better. Justice Krishna was sitting there. And then when the hearing started, Justice Krishna said, how is it a contempt? How is the contempt? Let us drop it. So they dropped it. That's a reported order in the papers. So therefore, Supreme Court, the High Courts are quite liberal, very liberal. And even if some order is passed against you, it's appellable. Single judge passes an order, it goes to the division bench. Criminal contempt in any case has to be a division bench. Then it goes to Supreme Court. They never punish you harshly, right? Very rarely they put you inside. Now, the last item, and I'll stop that because the other is the legislature. Under Article 1053 and Article 1943, powers and privileges and immunities of each house, its committees are almost the same as that of the House of Commons in England. Vast powers of breach of privilege, not defined. So, there is a lot of danger, and today politics, lot of danger for media getting into trouble from any legislature party. So this is the area. But if they issue a breach of privilege notice, all that the Supreme Court would do or the High Court would do is this a breach of privilege? If this is a breach of privilege, then no interference, because the Supreme Court has held in the first case of Mr. Sharma, that Article 19(1)(a) and Article 1053 and 1943 has to be balanced, reconciled. And it cannot be struck down. It cannot be struck down. So if there is a breach of privilege, they have the power to act. But Supreme Court later case, Raja Rampal case, 2007-3 SCC, they have said, in any case, if the court finds that there is no breach of privilege, but they are abusing this power to take action against anyone, the court has the duty to protect the citizen because of Article 20 and 21 of the Constitution. So there are safeguards there also. You can go to the High Court or you can go to the Supreme Court. And mind you, this is a very dangerous power. I recall that once when I was a judge in the Supreme Court, in the High Court, an IAS officer, quite a senior IAS officer, he had issued a circular. He was the CMD of EGI, Mr. Rishikesh Panda. So issued a circular saying that no MLA will be allowed inside the guest house of the EGI without my permission. That circular got in the hands of some MLA. He made out copies and circulated amongst all the MLAs in the house. And Mr. Navin Patnaik, Chief Minister, when he walked into the assembly, all the MLAs got up and said, we want suspension of this officer. Immediate suspension. And Mr. Navin Patnaik couldn't follow. He walked back, right, to his office. And in the afternoon when he goes to the office, he finds a resolution, unanimous resolution, adopted by the House for suspension of this. So Mr. Navin Patnaik thought, I must protect my seat, perhaps. He suspended the officer. He suspended the officer. Then he moved, first this tribunal, then came to us. As a High Court judge, division bench, stayed the suspension, saying, Assembly has no power. Under the Act, All India Services Act, state government has the power. And state government has done it. Mr. Navin Patnaik has done it as a state government. But he has to apply his mind. Whether there is a grave offence, a grave misconduct, and whether suspension is required for any inquiry, no application of mind, state the suspension. I signed the order. My colleague on the other hand telephones to me, the other judge in the division bench, shall I sign this? No, why? Do you know the consequences? And what consequences? We may have to go inside. The House has the power. I said, I know the consequences. But we have to take that risk if we have to remain independent. And we took that risk. They sat down to decide what to go, what to do. Finally decided, no, we have to go to the Supreme Court. They went to the Supreme Court. Supreme Court did not stay it. And ultimately, it just issued a notice. Went on. And thereafter, they forgot about it. Right. So, you have to take, as independent journalist, sometimes you have to, if your commitment says do it. Do it. You have to face the consequence. Independence has certain price. Right. I am sure Mr. N. Ram remain. What suffering Indian Express did not go through in the emergency days, when newsprint was limited, when the Indian Express building was sought to be taken over in Mumbai. So for independence, you have to suffer, otherwise you can't be a journalist. If you are committed to journalism, please do it. And finally, so far as other rules affecting freedom of press is concerned, you can always challenge it under Article 32 or Article 226. The Supreme Court, if you see the judicial precedents, I have written some judgments of that. Article 19(1) way has been given a lot of expansive meaning. Very, very fundamental. Very, very fundamental. We don't allow that fundamental right for freedom of expression to be affected at any cost. Very rarely do we uphold the restrictions. We're very careful about that. I have delivered some judgments also. Cannot be lightly handled. You must have heard also Justice Chandrachud saying so number of times. Freedom of speech and expression has to be protected. It's very, very important. In my view, that's very important. And one area which I was hearing, if you have to really protect freedom of speech and expression and remain neutral, my view is the media houses should not own it. The business houses should not own it. Business houses should not own media. If they own media, they've got so much business interests. They're bound to come under pressure in any government in the interest of the business. Never. So, therefore, media houses should not be owned by a business family. This is absolutely necessary. At the end, I would say, for democracy, independence of judiciary is important, everybody knows. But independence of media or press is equally important. Equally important. You must have seen a few years back, presently it is better, how judiciary started crumbling. And along with it, how media started crumbling also. And that we should not. Neither judiciary should crumble, it should do its duty, nor should media crumble. Do your duty, and I'm sure if you do your duty, government and legislatures also will be under control. Thank you. Thank you very much.